Alright everyone, welcome back to the channel. And for everyone living in Connecticut, congratulations, you are still behind enemy lines. And that's what we're going to be talking about today. All the things that have been going on with a couple of lawsuits, one in particular, and then obviously something I noticed dealing with the portals, SLFU, that provided for us the electronic version, where your renewals are, your assault weapons certifications, and all that good stuff. I have a bunch of notes, and we'll be talking about the brief that was just submitted to the Second Circuit Court of Appeals dealing with Grant v. Lamont, which we'll get into. So I'll be looking at my phone and all that. So that's why I keep looking down. I keep looking at my notes, making sure I am on track. I don't want to miss any information. I want to provide as much as I can, basically that's I could have found or off the top of my head. I did reach out to some people to get more information, including PDFs of certain documents, and I have not heard back from them. And instead of waiting, I am just going to go. All right, that and my wife kicked me out of the upper part of the house, the kitchen area, mainly because she is busy making cookies for one of our dear friends that is in a home right now. All right. Best way to support the channel, obviously, buy the merch. Where do you find the merch? Down in the description below. Always going to have a link there for you. Best selling shirt right now is Guns and Ammo, because we all know America runs on guns and ammo. There's also Patreon. There is locals and various other ways. Help the channel out, help it grow. Goes a long way. Trust me. It helps me provide free content to you, because a lot of the stuff we do is not cheap. That, and also I want to give a special shout out and massive prayers to one of our viewers, George, who's going through some things right now. George, you are in my thoughts and prayers. And I know we talked the other night and you thought you were talking my ear off, brother. It's always a pleasure talking to you. I will be calling you here in a couple of days. Hopefully you are at home resting. All right, now to the video. First and foremost, we all know we have this stupid little SLFU portal, right? We log in and we're able to see our guns. We're able to get our AW certifications. Some of them are, say, pending. Some were like time ran out, so on and so forth. Did a video on that before. And so I want to make sure, go look, yada, yada, yada. All right, cool. Well, I was morbidly curious, so I decided I was going to log back into my portal, because I haven't logged into the portal in quite a long time, because there was really no reason to. So I log into the portal, and there's nothing there. I mean, there's no links for anything. I can see the portal, and it's got some verbiage on there, but I don't have access to a lot of things. Now, usually there's two icons in the upper left corner. One is for a pistol permit renewal, because that's how the state wants you to do it. From now on, do it online. All right? Well, it being missing is really not a big deal. My permit is nowhere near renewal. And from my understanding, that icon will only show up if you need to renew your permit. If your permit is good and you have years on it still, or you had just renewed it, that little icon is not going to be there. That's my understanding. Below that was the AW cert button, where you would log in, you click that, and then you can register your assault weapons to get certified through the state, blah, 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 right? There's a whole video on that. You already know my feelings on it. So normally I'd click on that and I was able to see the guns that were pending, but I was also able to see all the guns that I currently own in the state of Connecticut. Everything I've ever bought. Any gun that has a DPS-3 attached to it. Well, when I logged in, I said there was nothing. So my question is, where did it all go? Where did the database go? the state of Connecticut has this database that has all my guns, has all your guns. We could see that. And now all of a sudden it's gone. So we don't have access to that anymore to basically, I don't know, audit the state, making sure that their information is up to date. Because I know there's plenty of you out there, and you've told me in the past that you've logged in and you saw guns you sold like a decade ago. All right, I've heard people say, listen, I bought a bunch of guns and they're not even on this list. You know, I had to go through and manually add them. Right? Like we were all supposed to do. I don't know. Right? It's a searchable database, obviously, because you're able to look up your stuff. So I'm pretty sure the state can look up your stuff too. But I just want to know where that went. Now, originally I thought, okay, maybe it's the browser I'm using. I'm obviously using a Mac. I was in Safari. I was like, all right, I will try Google Chrome. Actually, I had to install Chrome. Jumped into Chrome, put all my information in, nothing. The portal looked exactly the same. The information was missing. There was nothing there. So I was like, okay, maybe it's a Safari and a Chrome thing. So I'll try the Brave browser. Then I tried Opera, and I tried a few others. It was all the same. So I know it's not on my end. It's not the browser I'm using. So before you jump in the comments and start ripping me apart about the Mac and what browser I'm using, because I know some of you out there are like, I use Bing and that's it, or whatever it is. I know some of you probably still use Microsoft Explorer or Internet Explorer, whatever the hell it was called, i.e. Internet Explorer. Shit, that shows my age. I couldn't find it. Maybe you'll have better luck, so do me a favor, after this video, go log into your portal and see if you can see anything, and if you're able to send some screenshots my way. I don't know if you knew it in the comments. Worst case scenario, you can go to Facebook, Instagram, wherever, and you can DM me, shoot me messages, put it in the comment section, whatever. Let me know if you can see the portal, all right? Basically, hit up the comments and be like, hey, it's just you, my guy. I see everything just fine, all right? So I don't know what's going on with that. So there's the update on that. Now, let's talk about Grant v. Lamont. So what is Grant v. Lamont? Well, if you're not a member of the CCDL, then you probably have no idea. And I encourage all of you to become members of the CCDL. It is free to join. There are something like 43,000 members in the state of Connecticut. However, there are only a few hundred that are probably active, that go to the meetings, that really pay attention. I think everybody that joins should actively pay attention, donate time, money, if you can, to help the CCDL fulfill their mission statement. They are there to defend your Second Amendment rights. The NRA, the GOA really don't do much around the state of Connecticut because, well, face it, we go behind enemy lines. This state, when it comes to the Second Amendment, is trash. It is not as bad as Massachusetts or New York or some of the other states that surround us, but it's still garbage, all right? We are not a free state. We are not like West Virginia or Tennessee or Utah or Montana, North Dakota, you know, normal states. They really hate the Second Amendment, therefore they must hate you, the Second Amendment lover. I am a purist. The Second Amendment is written basically in black and white. It spells it all out. And I try to go through and be a Second Amendment evangelist. That's how I look at myself. So let's talk about Grant v. Lamont. Eddie Grant, God bless you, sir, is the defendant in Grant v. Lamont. The CCDL and Eddie and a few others are suing Lamont and a long list of other people about the assault weapons ban, the others, large capacity magazines, which are technically standard capacity magazines, and all that good stuff. All right? And we'll get into the nitty gritty. But this whole thing is up at the Second Circuit Court of Appeals. which we know damn well never really rules on our side, even though the Supreme Court has handed down rulings like Bruin and there's a bunch of others. A lot of these Court of Appeals just seem to ignore that and do what they want, which really pisses me off. So, a couple of days ago, the CCDL had put out on their social medias that they had submitted the brief to the Second Circuit Court. All right? And I'm going to pull that up right now. So this is case number 23-1344. I am currently looking at document 108. I was not able to find it on any of the legal websites. A lot of the documents ended at 76. This is a relatively new one. The CCL has provided it via their website. Unfortunately, I was not able to save it as a PDF, pull it down, or print it. You're only able to view it online. So I'm going to scan through it. You'll see the jumps in the video as I scan through and give you the highlights. There's 38 pages. I have already read through it, but I'm not able to highlight certain areas, so I've got to jump through it, and I'm not going to waste your time taking care of it. So the introduction. Let me start with this. We'll go back through the table of contents. All right. So 23-1344 in the State's Court of Appeals for the Second Circuit. Eddie Grant Jr., Jennifer Hamilton, Michelle. It lists everybody that's involved in this case. They're the plaintiffs. All right. And then it lists your defendants. All right. The plaintiffs are the appellants. I'm not a lawyer, so if I slaughter these names, whatever. The defendants will be known as the appellees. I'm pretty sure I'm pronouncing that right. And it lists all these people that they're suing, including Lamont. So it's known as Grant v. Lamont. All right. The lawyers that are representing Eddie and they're representing all the plaintiffs through the CCDL. You have your three lawyers. Cameron Atkinson. Good guy. I know him. Great lawyer. Craig Fishbein. Now, some of you may know Craig. He does help teach pistol classes at a certain place that shall not be named. He does their legal briefings. He is not only a lawyer, but he is also a state rep. And when they were crafting HB Satan 7, there was a bunch of crap in it. Craig did his very best to get a lot of this stuff taken out. Remember, 40% of the original bill was pretty much removed. And I think it's actually a higher percentage than that. Trust me, a lot of crap went through, but Craig did his best to get what he could out. And then it's also represented by Doug Dubitsky. Probably slaughtered that last name. All right. So those are your three lawyers. So let's get into the nitty-gritty. Get back through the table of contents. This is why I wish I had a PDF version. All right, the appellees. Heart-wrenching references to Sandy Hook tragedy and other criminal misuses of a firearm is a calculated appeal to the courts to abandon legal principles and decide this case on raw emotion. See, that's what the problem is when they argue these cases, one side argues via emotion, while everybody else should be doing it logically. What does the law say? Is it or is it not against the law? Is this law constitutional or not? But it's all on how we feel. Well, they're black and they're scary and we don't like them, so, you've got to do these. I don't like it. It goes on to say the appellees urge the court to resist creating a new constitutional right to possess an AR and other assault weapons, and they then tell you where the definition is of those. further sound the alarm that the appellants are asking the court to find constitutional protection for weapons like grenade launchers, and they list a few other things. All right? In the second paragraph, it says, Bruin expressly forbids courts from considering sensationalized and macabre portrayals of firearms when considering whether the Second Amendment protects their possession. That's just because it looks scary, just because bad actors do bad things with these, doesn't mean you can't have them, right? And the court is supposed to look at it blindly, because justice is blind. Does the Second Amendment protect this, or does it not? And Bruin says it most certainly does. Why we're still having this argument in the courts and we're still having this discussion is beyond me. I mean, Bruin pretty much said it from the Supreme Court. You have a right to bear arms. Anything and everything, right? I'm a firm believer if the government's allowed to have it, I am, as a citizen, I also am allowed to have it. It's a check on power, right? Nobody has more power than the other. It's supposed to be a check on the government. The appellants also do not ask the court to recognize any new constitutional rights. Rather, they ask the court to faithfully apply existing precedent to find that the Second Amendment protects a right of the appellants have always possessed, that the Supreme Court has recognized and affirmed the Supreme Court precedent and parts of the New York State Rifle and Pistol Association versus Cuomo, which I'm not going to give you the case numbers on that, which remain binding law, compel an objective, dispassionate inquiry into whether specific banned firearms are commonly owned for lawful purposes. That's what it came down to, is they could not ban commonly owned guns. AR-15s and the like are beyond commonly owned. They are America's rifle. Everybody has them. It is the most popular platform when it comes to a long gun that's semi-automatic in our country. They're everywhere. So saying that it's unique or uniquely dangerous, they're full of it. It's a bunch of crap. Right? They just don't like them, so they want to ban them. And all these are really technically feel-good laws that really don't do anything. All right, sorry about that jump, but I was looking for the right paragraph. So they go on to say that the Second Amendment's dangerous and unusual exception to the threshold textual analysis Bruin requires. Bruin, however, clearly established that the textual inquiry and the historical, i.e. the dangerous and unusual, exception inquiry are distinct and separate. And that it is the appellees, not the appellants, who bear the burden on the historical exception. Second, the appellees ask the court to limit the Second Amendment protections exclusively to self-defense, but the Supreme Court has recognized that the Second Amendment protects all lawful purposes for owning firearms. Third, the appellants invent out of thin air a novel interpretation of the historical, dangerous, and unusual exception that directly contradict the Supreme Court and court's precedent, relying on linguistical gymnastics that ignore historical context. The appellees ask the court to adopt new, unusually dangerous weapons exception to the Second Amendment, which does not appear in any Supreme Court case. This court, however, may not overrule the Supreme Court and fashion its own exception. Additionally, the appellees' proposed new exception lacks any strong foundation in history and is directly contradicted by historical sources that recognize the objective common use inquiry contemplated by the dangerous and unusual exception. All right? So, common use. AR-15s are pretty common use. All right. When they say they're dangerous, they're not any more dangerous than any other firearm. Okay. And they used, the linguistical gymnastics. We all know AR-15 shoots a glorified 22. You can't hunt with it in the state of Connecticut. Why? Because it's too small of a round. It's not going to actually drop the deer. So you have to use a larger caliber. At this point, they're just trying to ban the stuff because it feels good to their constituency. They want something to be done, so they're going to do whatever it is. All right, even if it's unconstitutional, which is a load of crap, in my opinion. And yeah, when they drafted the new assault weapons ban, they jumped through some pretty imaginative hoops to kind of justify it. And I hope that the Second Circuit Court of Appeals sees through the BS and just crushes this whole damn law. All right, moving on. Let me look at the next page. What do we got here? Oh, let's see. The argument. The district court applied the correct preliminary injunction standard because the appellants seek a probationary injunction. Oh, I said that wrong. Prohibitory injunction, not a mandatory one. All right, so they're just talking about stuff. It's the problem with reading these things is it's full of legalese, and that's not my cup of tea. That's reading it sometimes like it's like trying to read, IKEA instructions. That's what it feels like to me. So the fact that people write all this, I prefer just stuff in plain English, for the layman, because I am not a lawyer. So in the argument, they also say, like some states, Connecticut regulates the carry and purchase of firearms with background checks and a permitting system, which the courts have ruled is okay, they can do that. Connecticut regulates it with added stuff too, like DPS 3s. And not only are you filling out your 4473, but you have to fill out the state specific DPS 3, which we all know I get a copy. FFL retains a copy, state police get a copy, and your local police department or first selectman get a copy. So everybody gets to know what you bought. You can't buy anything with anonymity. I love the ones that are like, I buy all my guns with cash, so they can't track me. It doesn't matter. Connecticut is tracking you, regardless. So whether you use cash, a credit card, that information is getting to all the people that want to know. A person is seeking to carry or purchase a pistol or revolver must obtain a pistol permit under Connecticut General Statute 29-28 or a handgun eligibility certificate under Connecticut General Statute 29-36. See Connecticut General Statutes, blah, blah, blah. A person seeking to purchase a rifle or shotgun must obtain either a pistol permit or a long gun eligibility certificate under Connecticut's General Statute. So regulating the sale of long guns. Regardless of what the permit or certificate of a person chooses, obtaining such a credential is a prerequisite to purchasing any firearm, and a single permit or certificate covers every firearm purchase that person may make, regardless of the make or the model, for as long as the permit is valid and the credentials are issued to that person, not for the firearms. I'm reading through it. It talks about the only action appellees would have to perform at the time of the appellants were to purchase one of the currently banned firearms is to check the appellant's criminal history with a standard National Instant Criminal or NICS background check, exactly as the appellees currently do upon any purchase of any currently legal firearm, be it a pistol, revolver, or a long gun, by a person with such a permit or certificate, according to the general or Connecticut general statutes. An injunction would not compel the appellees to do anything they are not already doing. Nothing in Connecticut law requires the appellees to issue any new pistol permits or pistol certificates or long gun eligibility certificates every time someone purchases a new firearm. Thus, nothing in Connecticut law supports the appellee's frivolous contention that state officials would be mandated to process applications and issue permits or certificates for appellants and perhaps others who are now wanting restricted weapons. So the state's arguments saying getting a stay on this in the meantime is basically a bunch of crap. They're just lying. All right, so I got one for you as I do weird things with my phone. All right, so one of the other arguments the state is using, all right, because they're now talking about with HB 6667, banning the others, pre-bans, all that jazz, that if the courts were to find that a AR-15 ban, assault weapons ban is unconstitutional, it would absolutely unravel the law. Well, Fishbein, Cameron, and the other lawyer said it's well established that if a provision of a law is found to be unconstitutional, there is a presumption that the unconstitutional provision is severable from the rest of the law. See Reagan v. Time, Inc. All right? And they just go on to explain more. So basically, if the courts are like, hey, you can't ban AR-15s, and you can't ban magazines, right? You can't limit the magazines arbitrarily. They, wherever that is in the law, nixed. Everything else in the law gets to stay. It doesn't nuke the law itself. All right, so here's another highlight that they write. And I'm just going to give it a highlight, and then it obviously has the definition they explain the highlight. It says the Second Amendment's text presumptively protects all bearable arms, and the appellants, you and me, have no burden to show that the modern sporting arms are not dangerous and unusual in a textual analysis. So basically, the burden is not on us. We don't have to say, well, this is why it's not dangerous. This is why it's not unusual. It's not our job, right? It's protected under the Second Amendment. Done deal. We don't have to show you why it is. It just is. It's pretty simple. But of course, they try to put the burden of proof on us when the burden of proof is on them, right? It's almost like, you're guilty till proven innocent. When you go to court, you are supposed to be considered innocent, and the burden of proving that you're not is on the police or on the prosecution, so on and so forth. But we always joke, in the state of Connecticut, if you are a permit holder, you are always going to be guilty till proven innocent. All right? So if you were to engage a home intruder, you know that gun's gone, your permit is gone, you are being arrested, your life is over, it's all ruined, there is no presumption of innocence. Even if it is clear-cut, like self-defense, you were protecting your family, you're done. Why? Because you're guilty. And that's just how it works. All right, their fourth highlight. The Supreme Court precedent established that the Second Amendment protects all bearable arms commonly possessed for all lawful purposes, not just those possessed for self-defense. Because it's one of their arguments. It's like, well, no one uses an AR-15 for self-defense. Well, I hate to tell you this, but I do. That's a primary to me. Handguns are secondary. Shotguns are tertiary. It's not a tit for tat. If somebody is breaking into my home and they're armed, more than likely they're going to be armed with handguns. Why? Because they're small and concealable. Well, I'm not going to fight back with the same thing they have. I'm going to use something that has further reach, more power, and is a little more easy to control in the heat of the moment. All right? So, I don't understand their argument like, well, no one uses it for self-defense. Well, I do, but that's not even the point. The point is, you can't say, well, nobody uses it for self-defense, therefore we can ban it. No. No. That's not how it works. And then it goes into the breakdown. I will literally have, down in the description below, I will have links for this. If you want to go read it, it is dry. As dry as anything can be. I commend the people that write these. All right. And the fifth point that they're making in a court case, Catano versus Massachusetts, confirms that the dangerous and unusual test is a conjunctive test, not a dangerous or unusual or unusually dangerous test. All right. And then they go down and break it down. Now, Barney style, they're using all the legal mumbo jumbo, and I get why they do it. All right, the sixth argument they're using. Assuming that the dangerous and unusual test is up for historical debate, the historical sources actually point to a narrow interpretation that the one that the Supreme Court currently recognizes. So then they go on and argue, you can't, it's very narrow. It's got to meet this criteria. Okay. That's a full breakdown. I think there is a seventh one. Then it goes into the conclusion. So basically the conclusion is, for the reasons stated herein and their opening brief, the court, Second Circuit Court of Appeals, should reverse the district court's denial of preliminary injunction enjoining Connecticut general statute, and it lists all that stuff, and then remand this case with instructions directing the district court to enter an injunction against, I gotta turn the page, the appellees enjoining them enforcing Connecticut general statute, blah, blah, blah. Respectfully submitted, Doug Craig Cameron, attorneys for the plaintiffs. All right, I hope you followed all that. I literally think I lost myself along the way trying to go through all this, but their arguments are pretty much that, hey, you Connecticut, you guys can't reinvent the wheel. The Supreme Court has said this, and this, and this, and your law violates this, this, and this, because you are just making it up as you go along. You are using linguistical gymnastics to try and make a law work, even though it doesn't work. Now, the problem is you're dealing with courts that pretty much hate you. So God only knows where that one's going to go. I wouldn't get my hopes up. In fact, I would just move. Get out of this godforsaken state. Because I don't think anything's going to change anytime soon. But who can make it change? Well, you can. And I keep saying this, but go vote in November. Get rid of all these people. Get rid of the one side of the aisle that wants to take all your stuff away and ban this, that, and the other thing. And get rid of all the people who tell you to your face, hey, I support you and I support the Second Amendment, and then go vote against it. Because God knows there's plenty of rhinos out there. Get rid of them all. Get rid of anybody who is not supporting the Second Amendment. So in closing, I keep pushing my glasses, they're sliding down. In closing, CCL is doing stuff. I know when people get online and moan and groan and scream, ah, what are they doing? There you go. They're doing stuff. All right? I've told you before, the CCDL is not about sharing a ton of information. They are not trying to play their hand and show everybody what they've got up their sleeve. They do in due time. Rest assured, they are working behind the scenes to protect your Second Amendment rights. And the state is doing everything they can to curb them. It's a constant battle. And the best way to support the endeavor of the CCL is to join, give your support, give your time, and maybe we'll just win this. But who knows? I want to give a special thanks to Eddie for putting yourself out there. It is your name and a few other names on this, but it is Grant versus Lamont. So you are the poster child. You are the one that'll get dragged through the mud, through the courts. You are the one that's going to be on the tip of the tongue in the state capitol when they're talking about, you know, basically in the nicest, they say it in the most nicest way, but they're talking about the shitbag Second Amendment people. That's us, because that's what they think of us. Honestly, you know damn well if they could, and if there was an appetite for it, they would take away everybody's guns, and they would have a monopoly on violence, and then they could do whatever they wanted, and we wouldn't be able to fight back. That's how they roll. Me personally, everybody should have guns. If you can legally buy guns, then get your permit, get your training, go buy guns, protect yourself, because the winds of change are blowing. And unfortunately, I don't think they're good. Read the tea leaves. I think we're in for some tough times, guys. So, but that's all I've got for you in this video. Please like, share, subscribe. According to the analytics, the vast majority of people have not subscribed to the channel. So if you're one of them, it doesn't take much. Just hit the subscribe button, click the little toggle the notification bell, so you'll get notified when I put up a new video or a new community post, a new short, anything like that. It takes 3 seconds of your time. Please subscribe to the channel. I will see all of you in the next video. God bless. Good luck. Keep your head on a swivel.